Hello, everyone. Welcome to our webinar, Inside Compass vs. Zillow, what the hearing reveals about the forces shaping real estate. Today, we will be joined by Compass President Rory Golod and Compass Chief Legal Officer Ethan Glass. They will examine the public evidence and testimony from the preliminary injunction hearing, explore what's at stake for homeowner choice and an agent's ability to compete and advocate for clients, and look ahead to how the judge's ruling could shape listing visibility, industry standards, and agent guidance heading into 2026. It is my pleasure to now turn it over to Rory Golod and Ethan Glass.
Good afternoon, everyone. Thank you for taking the time to join us. My name is Rory Golod, President at Compass. A few weeks ago, we marked a significant milestone in a legal conversation that impacts how all of us in this industry, regardless of which brokerage you're with, market homes and serve our clients. We don't know yet how the court will rule in this case of Compass vs. Zillow, but a few weeks ago, the court here in New York heard testimony and reviewed documents about the power that online portals have and how that power is reducing consumer choice, limiting agent competition, and imposing restrictions on our industry. The core issue here, though, isn't about two companies battling against one another. It's about choice versus control. This is about choice versus control. Specifically, we believe at Compass that every home seller, regardless of which agent or company they choose to work with, has the right to market their home as they want, so long as they comply with local laws and regulations. We also believe that every real estate professional, regardless of what company they are at, has the right and even the obligation as a fiduciary to offer their clients customized marketing options without facing penalties. Regardless of Compass, we believe every agent in this industry should be able to help their clients market their home however they feel is best and what those sellers deem is best for their home without being told what to do by a company. Now, to help illuminate the hearing and the details around this, I'm very excited to be joined by Ethan Glass. Ethan is our Chief Legal Officer here at Compass, leading this case and brings decades of experience, both in antitrust law, but also in the real estate industry. Ethan, welcome. Thank you for being on the call today.
Thank you, Rory.
So just to help level set for agents that are joining from various brokerages, can you just remind everyone exactly what this specific hearing was about?
Absolutely. So in the week before Thanksgiving, we had a hearing before a United States federal judge here in New York about Compass's motion for a preliminary injunction. Now, a preliminary injunction is not a final decision on the case. That'll be decided by a jury at a later time. A preliminary injunction is a request that the judge tells Zillow it cannot enforce its standards until that final jury trial. The judge took evidence, both in terms of sworn testimony as well as documents, and she is currently deciding whether or not she is going to issue the preliminary injunction or whether or not she is going to wait until the jury trial.
Now, with these, it's sort of rare for people to be able to get a look behind the curtain at the proceedings. You were obviously there. So after 4 days of testimony, what was the main narrative that emerged regarding how agents do business?
So what struck me as an observer was how this case is really about control versus choice. Our belief is that agents, home sellers, home buyers, brokers should all have the choice, so long as they're following the law, to run their businesses however they want, to sell their property however they want, and to fully compete by offering their clients all kinds of different options. Now, some portals don't want those choices because the choice may lead to listings being found elsewhere. But our view, and what I think came through clearly at the hearing, is that home sellers want choice. Of course they do. Home buyers want options. Of course they do. And agents and brokerages want to be able to compete for those home sellers and home buyers by offering them all kinds of innovative ways to buy and sell homes.
So one of the most interesting things about this one in particular, though, Ethan, was that the court actually heard from active agents, from real estate agents in the field doing this job every day. Can you share and just summarize for everyone what they learned about the day-to-day reality for agents given what's going on in the industry?
So from my perspective, that was a critical piece of this entire hearing. It is indisputed that an agent is the one who has the direct relationship with the client, who can best tell us what clients want and what clients don't want, and who competes to be hired by those clients. Brokerages and portals merely support those agents, provide them with resources to be able to serve their clients. So it is critical when a case is about the buying and selling of real estate to have had agents come and testify about what their experience is, not only dealing with home sellers and home buyers, not only dealing with brokerages and portals, but about how real estate really works. And I'm really proud that we had a courageous agent come to the hearing and explain to the judge how her business works and how clients are served by agents and how agents compete for those clients.
Yeah, I can imagine that was really important just to have that on the ground context, given the day-to-day experience that agents are having in this. What should we expect over the coming months as we look towards next year? This is obviously a long process, but what can we expect in terms of the timeline of things as it continues to unfold?
So right now, the decision is for the court to make. She doesn't have any deadlines that she needs to abide by. She can decide whenever she wants. So a decision can come out at any time. We don't know when she will decide, but we are confident that the court is taking the evidence very seriously. There were hundreds of documents and 4 days of testimony for her to work through. So she's got a lot of work ahead of her, but a decision could come out at any time.
Well, thank you, Ethan. So now I want to transition and walk everyone through the evidence that was presented and shared during the preliminary injunction hearing. Everything I'm going to pull up today is evidence that was shared during the hearing at court and was produced for the court, and our actual documents and materials from Zillow that were shared at court. Now, first, I think it's really important for everyone just to be grounded in the Zillow ban is not a ban against private listings. Right? There's been a lot of speculation out there in the market and quite frankly, some rhetoric that's been a little confusing there. The Zillow ban is not a ban against private listings. Private listings exist today. It is only a ban of the public marketing of listings that are not on their website. This is an FAQ from their publicly released FAQ on the Zillow ban. And nowhere in here does it say anything about banning private listings. What this ban is about is the public marketing of listings that are not on their website. Any listing that is not on their website that's marketed publicly, whether it's put on social media, put in a big email newsletter, put on another website or another portal that is not on their website, that is what they say they will ban. Now, one of the first things that come out that was quite significant was testimony from Zillow's CFO. Zillow's CFO testified that Zillow presented to Compass a deal with an offer of anywhere from $1.3 to $1.6 billion of annual revenue uplift. So that was a deal that was presented to Compass that Compass could engage with Zillow that would pay to Compass somewhere between $1.3 to $1.6 billion of incremental revenue and would give Compass the opportunity to quote unquote double end thousands and thousands of deals by taking all the buyer leads on Compass Coming Soons and giving them back to Compass to distribute to its agents. Again, we've heard a lot of noise in the market that the only reason that Compass was aggressively advocating for homeowner choice and fighting this fight was because Compass was trying to double end deals or make more money. This is the most clear example that this was never about money for Compass. This was never about double ending deals, because if it was, $1.3 to $1.6 billion is a massive sum of money, and the ability to double end thousands of deals was presented to Compass, and Compass flatly rejected that deal, as you can see in the statement here. And again, this has been covered a little bit, but has not been covered enough, quite frankly. This is one of the most important takeaways, and one that is really, really important to resonate with people, that this has never been for Compass about money. This is not even about Compass agents. This is about all agents and choice versus control. Now, some of the documents that came out were documents that Zillow created amongst its senior leadership team. And so back in December of 2024, months before the Zillow ban was announced, the Zillow senior leadership team and its executives got together and started to put together ideas and put a number of things on paper in a document. And many of those documents we're going to share today. Now, one of these documents talked about what they thought the world was going to look like. And some of the highlights in here were the summary said, it is probable that the Clear Cooperation Policy, CCP, will go away. So Zillow believed that clear cooperation would go away. And without CCP, it would be up to MLSs to set standards. They saw that as a world where large brokerages would hold a lot of power, since MLSs are dependent upon them for driving membership and dues. And then they therefore expected brokerages to drive towards an erosion of the CCP rules. They also believed that it was largely inevitable that most MLSs will widen the private marketing window to 14 days. So going from a one-day CCP rule to 14 days, opening up markets to exclusive listings. Additionally, they said CoStar and Compass can be expected to continue to relentlessly support PLNs, private listing networks, / coming soons, with potentially negative implications for Zillow without appropriate preparation or action. So what Zillow thought, according to these documents, was that CCP would go away, that many brokerages would want to move to a place where there's a bigger window for pre-marketing, and they had to do something about it, in this case, prepare and take action potentially. Now, in that document, they also said, while the majority of sellers do want their listings published widely, which again, just to be very clear, is something Compass has always been very forthcoming on. We've said publicly many times, 94% of our listings that start in the pre-marketing phase go to the MLS, go to the broad market. They said that sellers also trust their agent to the extent that a subsegment will go along with coming soons / private listing networks. Brokerages don't need to take the majority of listings private. Once brokerages can claim even a small number of exclusive listings, they start a flywheel in that market. The effect of this on Zillow will be erosion of traffic and eventually revenue. While we can combat this with direct-to-consumer / seller marketing to convince sellers to get their listing on Zillow, this could gain enough traction in the meantime to hurt us. So what Zillow stated was that they thought this would actually erode their traffic and hurt their revenue, and that would be detrimental to them. So clearly their traffic and their revenue was important enough to put into this document and start to consider. And in another document in April, they again clarified this when they talked about what is happening, that Compass, in this case, has made an aggressive bet on a landscape without CCP. That why do they care? In the document said, listing inventory is critical to our value proposition and our business, being Zillow's business. What do we think is going to happen? This will result in a proliferation of coming soon listings at large brokerages, starting with Compass, but with a contagion effect across all other large brokerages. So they believed that brokerages, which represent the market speaking, that there'd be a lot of coming soon listings. Again, coming soon listings are available to everyone. They are not private. Coming soon listings at Compass are on compass.com for the whole world to see. And then they said, what do they do about it? Our strategy, be Zillow's strategy. Carrot, incremental product features for agents and brokerages, and stick, which was their ban, the Zillow listing access standards, and as needed enforcement. So what were some of the things they were contemplating for enforcement? Well, we will get to that shortly. Now, in this document, it also said that, quote, if initial tactics look to be insufficient, we, being Zillow, will escalate carrots to friends and sticks to foes. Carrots equal more direct payment for content. Sticks equal listings ban and Zillow products ban at brokerage level, local or national, to discuss. The goal is 90% of listings on Zillow and isolate Compass and any other bad actors that emerge. So they had a carrot and stick strategy that their legal team put together of how they were going to handle this. Now, within the document, they outlined examples of hardline tactics that they would put in place. Here are a couple of them highlighted. One, sue or support a lawsuit against an agent or brokerage for violation of fiduciary duty. So an example of a hardline tactic was that they would sue an agent who chose to put their listing not on their website first. As we go through this, I want all of you to take a moment and step back from real estate for a moment. Pretend that we're talking about Uber and sub that in for all these examples and use Lyft or even driving your own car as the other side of that. Imagine Uber said, you know what, if you ride with Lyft or drive your own car, well, the first thing we're going to consider is we're going to sue you. Certainly, that would obviously be a big problem if they were to do that. Second, when they looked at their escalation framework of who do we target, they could target individual listings, individual agents, or entire brokerages. One of their pros, among pros and cons for targeting entire brokerage, was more collateral damage equals more impact, more outrage if directed at brokerage. So a pro for them was that by banning an entire brokerage's listings, they would create outrage directed at brokerage. A con for them in that was if they target the entire brokerage, more collateral damage equals more innocent parties affected. So clearly they know that innocent people would be hurt by having listings banned. And then third, what's the desired outcome for targeting an entire brokerage? Get agents to switch brokerages, get brokerages to change policy. Agents choose to work at brokerages for a number of reasons. And they should be free to choose their brokerage based on which company they think is going to best support their business and their clients. It should not be a desired outcome that those agents have to switch companies just to be able to pre-market listings and support their clients. And it seems very surprising that Zillow doesn't employ agents, would be in the business of actually influencing which companies that agents wanted to work at. That's a decision that should be up to an agent, not to a company. In the individual listings framework, the desired outcome for individual listings was get seller to switch agents, put listings on Zillow. Agents work tirelessly and incredibly hard to win listings, to build the trust of clients. They spend thousands of dollars, hundreds of hours, work really hard, in many cases spend years cultivating these relationships to win listings. For the desired outcome for those listings and those sellers to switch agents because of a Zillow ban is very shocking and startling and should cause us all to pause for a moment. Again, imagine if Uber was banning riders into having to work with them. This document then went on to say, so if we put it together, what does the plan look like? In there, the recommended plan, we could also throttle the listing quality of all of the agents' other listings. So Zillow was prepared to take an agent's listings and diminish and hurt the actual listing quality, pushing them down further so that consumers wouldn't see it. So if you're an agent and you have 5 listings and one listing you wanted to pre-market and the other 4 you didn't, those other 4 would be penalized just because you chose to pre-market. So innocent people who had nothing to do with this would be hurt. It's actually a question of how many agents even knew this was happening or going on, or this was even being contemplated around. Goals. We want to punish the agent for choosing to put their listings on alternative networks. Of all the evidence we've seen in this case, these words are maybe the most shocking. Goals. We want to punish the agent for choosing to put their listing on alternative networks. Again, what would happen if Uber's goal was to punish riders who chose to ride with Lyft or drive their own car? What would happen if Google's goal was to punish users who searched on a different website? That is exactly what this says. That is by far the most shocking thing, that a goal of a company whose customers, the people who pay them, are agents, their goal would be to punish agents being punished their own customers just for choosing to put their listing somewhere else first. They also said, we want agents to leave these offending brokerages if they do not change. Again, there's no consideration in here for whether an agent wants to be at a company or not. They are saying that their goal was that agents would be forced to leave companies just because of the Zillow ban, completely throwing out an agent's own decision, their own ability to decide where they want to work and choose which company they want to be a part of. Now, at a SLT meeting, which stands for Senior Leadership Team, on December 17th, again, before this ever was made public, the Zillow Senior Leadership Team meeting agenda was, we want to be more aggressive with all hardline tactics to keep all listings in IDX and on Zillow. So they wanted to be aggressive with their tactics. We don't see anything in here about trying to support homeowners or consumers. We don't see anything about transparency. All we see is hardline tactics to keep listings in IDX and on Zillow. Everything about the hardline plans assumes we can be successful at using a hammer to keep sellers and agents on our site. Imagine for a moment, for the agents watching right now, if your strategy of how you got clients to work with you was to use a hammer to keep them to work with you. Imagine any company that we work with, that we pay for services or goods. How many of them, their intended strategy is to use a hammer to keep clients engaging with them? That's exactly what they said here in this document. Now, the testimony from their CEO this past November during the hearing, among a lot of testimony, one of the things was that they were helping the industry to strengthen the rules to preserve transparency. So we lobbied the National Association of Realtors and the MLSs to try to change that. And what they said was, and towards the end of last year, it became clear to us that that was likely not going to happen. So they weren't able to lobby that. We weren't making much progress. So we started to turn our focus towards what might we have to do to ensure we get fresh supply, that the marketplace remains transparent. So again, what did they have to do to keep fresh supply? What did they start to do in order to ensure that they had listings on their site? Well, one interesting thing was in February, completely out of the blue, there was a state senator in Illinois that filed a bill that would make CCP the law in that state. It said, provides that within 1 calendar day of the start date of any brokerage agreements authorizing the licensee to sell or lease the client's property, the licensee shall publicly advertise or market listed property for sale or lease on a platform or website accessible to the general public and any real estate licensees representing prospective buyers or tenants, unless the landlord or seller completes and signs a disclosure and opt-out form prescribed by the Department of Financial and Professional Regulation. Never heard of that before. That includes an express request to withhold the property from advertising and marketing it in certain acknowledgments. One question I've had since seeing this back in February even was with everything going on in this country that states around the country are trying to solve and state senators spend their time doing, it seems very odd to me that a state senator in a state such as Illinois would just out of the blue decide that an important bill to be crafted and put into law in that state was that all listings were publicly marketed on portals and websites where every single consumer would see them. And if they weren't, that they had to go through a ton of bureaucratic paperwork in order to make sure that doesn't happen if they choose not to. That seems very odd and very ironic, just given the timing. But I'll let you all draw your own conclusions from there. Obviously, there are a number of voices that came out against that. One example of that, Mike Golden and Thad Wong, the co-founders of At Properties and Christie's, said they were deeply concerned about the bill in Springfield that would mandate a one-size-fits-all approach to home sales. This bill would force home sellers, whether they want to publicly market their home or not, to publicly put the home on the MLS and syndicate it across a network of real estate websites within 1 day of signing a listing agreement. So then 1 day of signing a listing agreement, they're forced to immediately put it into the MLS. Proponents of this bill argue it's about transparency, but what's not transparent is the driving force behind the bill, as they said, quote, Zillow. So they said the $16 billion tech giant, worth more than the top 25 U.S. brokerage firms combined, is lobbying hard for this bill because, as it turns out, giving sellers and their agents options for how they bring a listing to the market is direct threat to Zillow's bottom line. Again, their words as real estate leaders in the industry. Zillow executives had internal chats in early April where they said, quote, I like this approach. Almost daily, we see another PLN private listing network. We need to give people pause. They also said that in their own documents, quote, to help teams understand they may not have all answers immediately, we're intentionally dropping big news without the terms and conditions of our standards as a means of deterring others from going down the private listing network path. This was before they put out the news of the Zillow ban. And so many people, when that happened, were asking, what's going on? What are the rules? What does the ban actually say? And Zillow was very vague at that time. Well, what they said here is the reason they chose to be vague was because they wanted to deter others from going down that path. They were intentionally dropping big news without the terms and conditions as a means of deterring people, creating confusion in the market that would hopefully deter people. There was then an email from a Redfin executive, and part of this case contends that Redfin and Zillow colluded together along with EXP to do this. And it said, quote, but I think just the idea that a listing could disappear from Zillow and Redfin without notice and without recourse because it was truly a violation of the policy will be enough to give listing agents pause. That's from Redfin's chief growth officer. Just the idea that a listing could disappear from Zillow and Redfin without notice and without recourse. Even as I say it, it's so surprising. And obviously, Redfin backed away from this ban and chose not to do it more recently. Then there was a text exchange between Zillow executives. And these are just a few of what were thousands of texts. Not a lot of new PLN announcements this week. That was our goal, to stop the PLNs, to stop the private listing networks. What is also interesting, if you actually look at the count of violations of listings, then you could see along the top right, it's how many violations, 1, 2, or 3 violations by brokerage. You can see the Compass agents. We had 1,063 agents who received violations, 1 violation, 127 that received 2, 36 that received 3 or more. As you can see on here, the next closest for that was 16. These numbers clearly speak for themselves that this was a targeted effort. So what you saw there was just a small piece of the evidence that was gathered in this trial. Hopefully that helps to illuminate what was behind this effort and why Compass believes this is a battle, not just for Compass, for any agent in this industry. We are doing this on behalf of all agents. Any agent should be given the ability to choose how they market homes and be supportive of their clients' best interests. Now, Ethan, before we wrap up, do you have any closing thoughts for the group?
Absolutely. Preliminary injunctions are notoriously hard to get. But this was important for Compass because it's not about Compass. It's about doing the right thing. It's about standing up and saying that home sellers should be able to market their property however they want for any reason, so long as they're compliant with the law. After all, it is their property. It's about agents being empowered to come up with creative ways to win clients, to win listings. It's about agents being able to run their own small and independent businesses without being told what to do by large companies. I would like to conclude by just saying thank you to the witnesses who came forward. It's incredibly difficult to testify in a United States federal court, and the people who testified were incredibly brave. I also appreciate the court's attention. This is a matter of significance, not just to Compass, but to every agent, every home buyer and home seller, every brokerage, every portal in the country. And finally, I'd like to thank our team. In-house, it was led by Timothy Letson, Terrence Leong, and Robbie Sweet. And our outside counsel was the excellent Shahira Soul at Kroll. Thank you, Rory.
Thank you, Ethan. We're all incredibly appreciative as an industry for all of your hard work. Again, everyone, this is not just about Compass. This is about every agent who sells real estate in the United States and works with clients, about supporting them and giving them the choice to run their business and work with their clients how they deem most appropriate. We hope today provided some clarity and gave everyone a little insight into everything that's happening. We will continue to share updates as this unfolds. We hope you all have a great day.
Thank you, Ethan and Rory, for walking us through the evidence, the broader implications for homeowner choice, and what this ruling could mean for the future of our industry. We appreciate everyone joining us today and engaging in this conversation. If you would like to see the entirety of Zillow's strategy synthesis document, which was presented as evidence during the lawsuit, please visit www.thetruthaboutzillow.com. Again, that is www.thetruthaboutzillow.com. Thank you for joining us and have a great rest of your day.